Good morning, good afternoon, good evening, depending on where you are. Welcome to our YouTube live show. We are running a little bit late today, but here we are. We're talking about Startup Visa for Canada, the only direct PR program as an active federal business immigration stream in Canada. The Startup Visa Canada program is changing quietly under the radar. Are you aware of all the differences and how IRCC is processing these cases? Do you know what the top 2 or 3 reasons are for the Startup Visa PR refusals for the last 2 to 3 years? Well, these are the things we're covering today. This is our YouTube live stream, unedited, uncensored, no special effects, exposed truth for our audience members, just like the rest of our videos on our channel. You're not going to see any slots here in today's live stream. And if you have questions, we'd be happy to answer them right after this quick intro. And of course, the content that we're covering today, you can post your comments or questions on any global residency or citizenship program that we cover, and we'd be happy to answer your questions. And that's what we do every Thursday, 11 a.m. North America Eastern Standard Time. Quick introduction. If you don't know me, my name is Reza, founder of Ingwe Immigration. And we help secure investments, residencies, and citizenships and beyond with over 20 countries in our portfolio. Opening opportunities for investors and serious professionals seeking returns on their investments or seeking alternative residence or citizenships. Our team is licensed both in real estate and residency citizenships, allowing us to help you with overseas programs or investments. We work both with B2B and B2C, meaning we cooperate with financial and investment advisors, real estate brokers, and directly with individuals and families. We've successfully helped thousands of applicants since 2018, and our existing portfolio includes Europe, Central America, North America, Caribbean islands, and even New Zealand. Whether you're seeking to invest in real estate abroad, aiming to retire comfortably, or enhance your quality of life with positive cash flow, find crypto-friendly tax countries, or perhaps even acquire direct citizenship without moving anywhere, or fast-track residencies, whether it's for yourself, your clients, or future generations. We do offer a diverse range of products. And of course, we're not a typical sales company. We educate you, we provide you the resources, guide you, help you weigh all your options, risks, returns, matching to your short, medium, and long-term goals. You can consider us as a custom solution provider. Our global partnerships and multilingual team speaking 10 languages ensure that no matter where you're coming from or where you're planning to invest or obtain the residency or citizenship, we're here to help you throughout the whole process. So now we're covering the refusal cases for Startup Visa. Here's the top 3 reasons that we have been seeing over the last 2-3 years. Of course, there's a lot of reasons for refusal of a permanent residency made under the Startup Visa program. And as you know, 1 to 5 co-founders and their families can apply together to obtain permanent residency when they've been endorsed through a commitment certificate, or as we know, there's a letter of support from a designated organization which is participating as in the Startup Visa program. The number one reason we're seeing recently is artificial transactions. This is what the IRCC officers are calling it as per the regulations. On the balance of probability, this is a quote, that the primary purpose of essential applicants entering into commitment with the designated institution, so-and-so, whichever designated institution, is for the purpose of acquiring status or privilege under the act described in regulations 89 subsection B of the Immigration Refugee Protection Regulations. Therefore, the applicant is not a member of the Startup business class as per the regulations 98.01 subsection 2A, and therefore they're refused. So basically, in a nutshell, they don't believe your startup is genuine. Okay. The next refusal reason is in line with the first one, saying that there's no genuine documents or efforts for the startup business made by the co-founders, right? So that also aligns with artificial transactions, but they don't see any genuine effort or supporting documenting. And we'll cover 1 or 2 of these cases today as well. And then the next one is essential members being refused. Hence, by default, all members of the starter visa group are refused. Another applicant in respect to the same business, and I'm quoting here exactly how they refuse you, the officers. Another applicant in respect to the same business as yours, identified as an essential member to the business in the commitment certificate, has been refused as a permanent resident visa. Therefore, you have not met the requirements of section 98.01 subsection 2 as described in 98.08 subsection 2 of the Immigration Refugee Protection Regulations, which basically means that you don't actually qualify or are not eligible as a startup visa business applicant. You're therefore not a member, and your application for permanent residency in Canada is refused. What does that mean? It means you're an essential member in your group has been refused. Therefore, everyone is refused. It could be a refusal. It could be a withdrawal, right? So if another applicant is applying for another PR program, and that PR program or their spouse, that PR processing is faster than your startup visa processing, IRCC will by default withdraw that essential member's PR application under startup visa and by default refuse everyone, no matter what, no exceptions. Okay. So that's important. Let's look at some cases in 2023, 2024, and 2025 related to PR refusals of starter visa that went to federal court for judicial review and were posted online. So we got 2024 was Dean Ho Trin versus the IRCC, the Canadian Immigration Department. It was a misrepresentation. Okay, so the IELTS was fake and it didn't match because, you know, IRCC has access to the British Council record. So when they see an IELTS, they verify it. So this person just submitted, or their agency submitted. A bit pathetic, to be very honest with you. So they were refused. And if they were an essential member, everyone was refused in that case. We were not sure if that was the case. So in 2025, we have Zohre Helmzadeh versus the IRCC, which is the Canadian Immigration Department. Language test scores were below Canadian language benchmark 5, threshold CLB, and the applicant requested substituted evaluation. So that means their score was below CLB 5, which is the minimum language benchmark in French or English that you need to qualify to apply for startup visa PR. And this person didn't have it. I don't know why their agent even or representative even allowed them to submit it. And then they requested, when the officer was concerned that they're not eligible, they requested a substitute evaluation saying they would retake the exam, right? So their listening score was 4.5, which is not 5, right? So they were denied. There is no substitute evaluation in startup visa. You either have the minimum requirements, minimum settlement funds, proof of language, the background police check, or you don't at the time of PR application. There is no way to update it later. On the date you submit, those documents are not there, you are denied, your application is sent back, and if you're an essential member, boom, the whole group is gone. So I'm not sure what happened there. Another case in 2025, Hiva Safar versus the IRCC, Canadian Immigration Department. Failure to pay the right of permanent residency fee on time. So this was a case that many people have shared on social media. It was like a serious blooper, and I do feel for the applicants, because the representative, the legal representative, did not pay the right of permanent residency at the time they applied for PR. And after several years of waiting for processing, it was refused based on this technicality. And the whole group was refused because obviously the essential members didn't pay. And that, unfortunately, you're not eligible if you don't pay the processing fees or the right of permanent residency. So that was a technicality. And to be honest with you, they would have to go and claim with the insurance of that legal representative. Agili versus the IRCC, Citizenship Immigration of Canada. Application deemed to rely on artificial transactions. So this goes back to what the top 3 reasons that we're seeing refusals right now is that the officer had concerns that the commitment and business intent were primarily to obtain immigration status, not genuine business activity for the startup. So she was refused. 2024, Human Damangir versus Canada IRCC Citizenship Immigration Department. Misrepresentation and group ineligibility due to non-disclosure of prior temporary resident visa refusal. So the essential member in this group failed to disclose on their original PR immigration applications prior refusals to, let's say, Canada, especially, well, it could be US, New Zealand, Australia, UK, but this case was specifically to Canada. So they're not in it, so they're inadmissible under the Immigration Refugee Protection Act, section 16, subsection 1, and section 41, subsection A, triggering a refusal for the entire SUV group under the regulations 98.08, subsection 2, meaning that if an essential member is refused, everyone by default, no matter what, is refused, no exceptions. So transparency, making sure you submit all of your prior refusals or applications for Canada or other immigrations around the world in your original PR application forms. If you don't, you are hit with a misrepresentation like this case, and you could undermine your entire PR application and the group. 2024, Rezai Oruji versus Canada IRCC. This is something that has been a trending case in the last 6 to 10 months. Similar cases have come up. Expired or invalid designated entity commitment certificate. Original designated entity withdrew the commitment, and then another designated organization tried to replace it during the processing time. IRCC had to refuse that. That just doesn't work. And we've seen other cases as well where IRCC has refused the case based on the fact that the designated organization, they never received a commitment certificate from the designated organization. And that's been a factor in the SUV world as well. But this has been rectified, and a lot of people have been more cautious about that, because IRCC has simply not received the letter of support commitment certificate from the designated organization at the time when the applicants are applying for PR, and there have been refusals in federal court in that, which is a technicality, and it's poorly done or managed by both parties meaning IRCC and the designated organization. How can they not have clear communication channels where if something is sent, it's validated and there's proof of it? So that has to be communicated directly with the designated organization to make sure they've got a system in place for that. There's another case that we've posted an article on our LinkedIn, which is Le versus Canada 2025. The SUV applicant was refused on their PR because the officer was not convinced regarding the activities and efforts of the startup business. Some of the things that they mentioned was artificial transactions. For the purposes of this division, I'm quoting, an applicant in the self-employed persons class or applicant in the startup visa business class is not considered to have met the applicable requirements of this division if the fulfillment of these requirements is based on one or more transactions entered into primarily for the purpose of acquiring a status or privilege under the Act, rather than the case of an applicant in the startup visa business class. So basically, you are doing this just for immigration. You're not actually doing this to also have a business. The officer found following problems: given the minimal growth of the startup business over the long period since the application was submitted. Moreover, in their business plan, the company's reasoning for their value proposition was not compelling and lacked validation. For instance, all projection and numbers and financial statements are doubtful and are not supported by logical reasoning or proof. Upon reviewing the document received in January 4, 2023, many attendances to designated entity events and researches are done, but no changes into business status. I'm not satisfied that the members are contributing significantly in their new business in Canada. The officer continued to question the startup business by stating that consequently, quote unquote, I remain concerned by what appears to be a lack of seriousness on the part of the essential applicants. I'm therefore satisfied on the balance of probabilities that the primary purpose of the essential applicants entering into the commitment by the designated entity so-and-so, we're not going to name them, is for the purpose of acquiring status or privilege under the Act and described in Regulations 98, subsection B, of the Immigration Refugee Protection Regulations. Therefore, an applicant is not a member of the startup business class as per the regulations 98.01 subsection 2A. Refused. In a nutshell, they didn't see that the business was genuine. The startup business was genuine. There was no effort, and all the startup founders did was attend some designated entity events, right? So bare minimum effort, bare minimum supporting documents. The next case is Neri versus Canada 2025. The officer used a typical explanation for the refusal regarding the genuineness of the startup business. The officer found that pursuant to subsection 89, subsection B of the Refugee Protection Regulations, he was satisfied that the primary purpose of the applicant's startup visa business venture had been to acquire residency status, rather than to legitimately engage in this business activity. Per that section of the regulations, such as artificial transactions, prevent the applicant from meeting the applicable requirements to qualify as a member of startup business class. So they were refused. What the officer quoted was, "I'm satisfied on a balance of probabilities that your primary purpose for entering into the commitment with the designated entity," I'm not going to name them, but it's all public records, by the way, "is for the purposes of acquiring a status or privilege under the Act, as described in subsection 89, subsection B of the regulations." The officer also noted that while the applicant was asked to provide contact details of the individuals whom he had hired or whom he proposed to work to realize his business, the contact details then provided by the applicant were either not in service, did not connect to the individuals in question, or were inoperative website links. So that's, again, pretty obvious. This is bare minimum effort, folks. Okay, these are obvious reasons why anyone would be refused. Another recent case, which included a startup visa work permit and PR, both refused, was Rezai versus Canada 2025. The officer's notes stated that regarding the refusal outlined the key points were: the company was incorporated in May 2022. The client has not provided the proof of the company operation viability, such as the company bank statements, financial statements, and operations accounts to demonstrate transactions that occurred. Client submitted a personal RBC account that shows a balance of $17,926.36, which is less than the minimum requirement amount for the family size. This is for the work permit. Client has not provided proof of investment they already put towards the business. No evidence of the investment funds received, that these funds are transferable, available, and unencumbered. So this undermined both the applicant's work permit, but their PR was also refused. Not because the work permit was refused, but because the genuineness of the business. Okay, what are the top 5 reasons? What are the top 5 most important factors, everyone, to plan for a successful PR application under the Canada Startup Visa Program? Avoid paper-based startups with no real investment plan inside Canada. Okay, attending a designated entity event and doing a website and a business plan and incorporating a business, that's not genuine traction. That is not something they're looking for. That is the bare minimum. Demand clear paper trail of investment funneled through the startup business Canadian bank account. Number 3, actual investment inside Canada for this new startup business. Expenses, financials, you need to spend it, right, inside Canada. Real Canadian partner to help with your startup business to gain traction, such as equity partners or joint venture partners who can really find customers and work on your project. Maybe they're research and development professors or scientists, who knows? But inside Canada, having a partner inside Canada that is part of the business legitimately and has stake in it can really help. Avoid outsourcing everything to overseas. That doesn't. So remember, the Startup Visa Business Program has 3 foundations: scalability globally, economic benefit, innovation. So economic benefit to Canada. If you're outsourcing everything to overseas, I don't see the benefit to Canada. Remember, we're always posting about key details for investors, entrepreneurs, for new programs, policy changes, and people seeking return on investment for their overseas investments, residencies, passport, or tax relief. And we're the number 1 source of the truth for the Canadian Startup Visa Program with no fluff. And if you're interested, make sure you subscribe to our YouTube channel because it's free. Top 5 misconceptions and mistakes that many startup visa applicants make in 2025 when they're applying or when they're under process. Number one, applying for a work permit under the Startup Visa program, not staying inside for Canada at least 6 months of the year while they wait for their PR decision. The biggest mistake is thinking that they can come and sell their families and return to their country of residence to continue working in their high-paying job without the need to spend more time in Canada as a startup visa applicant. The SUV per work permit is not intended to sell the family, and the actual main applicants of the startup business go back to their home countries or countries of residence, right? The whole point of the work permit is for the startup visa applicants, the co-founders, to come inside Canada with their families and to spend the majority of time inside the country, making sure their startup is operational. Applicants with a valid letter of support can apply for the PR to Canada and then the optional work permit without an expiry date. But they have to become an essential member on the commitment certificate to apply for the work permit. Misconception number two, venture capital or angel investors sponsor startup businesses and their co-founders would be prioritized and processed for their PRs in 1 year. This is the farthest thing from the truth, folks. All priority designated organizations are prioritized, whether they're VC, angel investors, or incubators, but none of them are processed in 1 year. This is impossible as of 2025 going to 2026. This doesn't exist. Okay. Priority designated organizations can include government-backed incubators, private venture capital, and angel investors. However, the processing time for the startup visa PR processing under the priority category is 3 to 3.5 years. There's no differentiation between the IRCC between these three types of priority designated organization as stated on their website. Only the non-priorities are differentiated. Number three, misconception number three. The main applicants under the Startup Visa program enter Canada on a 3-year open work permit need to reside or settle in the same city or province as their designated organization which issued the letter of support. Folks, there are no IRCC regulations which restrict co-founders in residing or working in different provinces or jurisdictions from their designated organization. The only restriction is that the applicants and their families should not plan or intend to settle in the province of Quebec, which is not part of the federal startup visa program. Here's an interesting fun fact which justifies this point. There's actually a designated organization in Montreal, Quebec, which is part of the startup visa program, okay? And all its startup visa applicants have to plan to reside outside of Quebec when entering Canada with a work permit or PR. And they cannot plan or settle in Quebec where the designated organization is located. Otherwise, they would be refused by default because Quebec is not allowed. Hence, there are no geographic ties between the letter of support and who issues it from which province and the main applicants, whether they were coming with a work permit or not. Number four, misconception. An essential applicant under the Startup Visa program can have their spouse apply for another PR program in Canada, and it would not affect the rest of the founders in the Startup Visa program. This is 100% incorrect. If an essential member of the Startup Visa group or the spouse of an essential member receives their Canadian PR through another program before the Startup Visa PR is processed, the whole group can be refused by default because one essential member being refused automatically or withdraws. So remember, if you've got two PR applications under process for IRCC, they will withdraw one by default automatically without your notice. If one of them starts processing before the other, which is the case, they will withdraw the other one automatically and by default refuse all the other essential members. If you're not an essential member, that's fine. You're withdrawn. The rest of the group members can continue. Misconception number five. If a startup visa applicant enters Canada with an optional 3-year open work permit, they cannot invest in side businesses or work for other employers. This is not true. As of end of 2024, the IRCC, which is the Canadian Immigration Department, announced that startup visa essential applicants can receive open work permits 3 years, which are renewable as well, which means that the applicant could work for any business in Canada, even their own, or part-time or full-time for other employers while they're involved in their own startup business. An open work permit has no restrictions except working in legal occupations, not the blacklisted ones, and also adhering to the regulated occupations or industries which require further medical background checks, such as healthcare and working with minors. Okay, so those were the 5 misconceptions, folks. What are the realistic timelines for the startup visa now, today? Well, That's a question everyone is asking. We haven't seen a lot of traction. Nobody's seen traction in the last 5 years, 6 months by the IRCC because they're literally in dormant stage. They're doing a lot of housekeeping. They're reinventing themselves. They may be announcing changes. Okay. So what's happening? Okay. What is really happening is that um, the PR processing for non-priority is going to be over 5 years. Okay. That's a reality. I don't care what your lawyer, your consultant, your agent told you. Okay, if you're in a non-priority designated organization, you're going to be stuck for 5 years minimum for PR. I don't care. Okay, who you are, where you're from. No discrimination. Second point, priority designated organizations will have a 3.5 year processing timeline. Okay, so if you're from a priority government-backed incubator, which is part of the Canada Tech Network, or a venture capital or angel investor, your processing time for PR right now is 3.5 years. So let's say 3.5 years is safer. It's not stated online, but this is the priority versus non-priority. These are the realistic timelines. How long will it take you to get a work permit? Well, from inside Canada, it can take 6 months. From outside of Canada, it can take 2.5 to 4.5 months. Okay, depending on the embassy you're dealing with in your region. Okay, so first you apply for your PR, then the work permit, and the work permit is optional. But for PR, remember, folks, I don't care if your agents, your lawyers, your trusted consultants, I don't care who they are. If they told you 1-2 years, they're lying. It's 5 years, priority 3.5 years. If you don't know that, that's a news flash for you. Okay, make sure you share this video with other applicants in the startup visa world, or your family or friends or colleagues or neighbors who are looking to apply for startup visa, because this video live stream is being posted. Let's go through the questions that we've had posted on our YouTube live session. And remember, we're here every Thursday talking about different programs around the world: US, Panama, Dubai, Portugal, Spain, Caribbean islands, Grenada, St. Lucia, you name it, we've got it. Mohammed Ibrahim says, I have applied for more than a year ago. My designated organization is non-priority. I did not receive an acknowledgement of receipt yet. What are the options to expedite the process? Well, I'll answer your questions. There is no process to expedite. It will take anywhere from 4 to 12 months minimum to get a file number, an AOR, for the Canada Startup Visa PR application. If you're non-priority, I've seen 18 months also. This is why we don't work with non-priority. It's too risky, too long, waste of time, waste of money. Okay. Vilas Desa, hi Vilas, how are you? IRCC processing SUV, when was the last refusal? We haven't seen a lot of refusals in the last 6 months or approvals. 6 months, IRCC is dormant. Keep that in mind. Max Phillip, are there any news regarding changes to Canada's SUV? Not yet. Nothing in the last few months, Max. But we will update you. We will go live. We will post on our videos as soon as there's some news that comes out. And we'd like to do a shout out to Max Rize 3214 as one of our top fans of our YouTube channel. If you subscribe and your settings in your YouTube show profile as your subscription information being public, we can always acknowledge you in our YouTube live streams and videos. So thanks to Max Rize 3214 for being a subscriber to our channel and one of our top fans, which YouTube has identified. Folks, we're here every Thursday exposing the truth, cutting through all the BS. If you think I'm crazy, well, maybe I am. No, just kidding. There's just so much BS out there about startup visa. We do startup visa. There's hundreds and thousands of agencies that do it, but nobody knows what the hell they're doing. Because if you look at the startup visa website, what do you see? You have IELTS, you have letter of support, you apply. This is how much it costs. These are the designated institutions. That's it. There's nothing else. Everything else, you've got to depend on people like us and lawyers and consultants and marketing people telling you what the hell is happening with startup visa. Okay. Max Phillips says, are there any rumors that least regarding news? Oh, wow. Okay, yeah, you're Max Philip. Nice, nice, nice. You're one of our top fans. Thank you, Max Philip. Um, so there are rumors all over the market, Max, okay, that the SUV is changing. This is what we've heard from reliable channels. In September, the startup visa IRCC unit head supervisor for that department is changing. The new person is coming and starting in September. They're doing a lot of housekeeping and internal changes now. There will be an announcement this year on new potential changes, maybe eligibility, maybe minimum investment and job creation. We don't know yet. I really hope they remove the whole essential member BS thing. So it could be this month, it could be in September, could be in October, could be in November. Nobody knows. Nobody has the crystal ball. Okay. If anyone tells you they know for a fact, it is BS. It's a lie. And that's what our channel is about. It's cutting through the BS, myth busting, and calling out anyone out there who's giving misinformation and misconception to people who have applied or are looking to apply for the permanent residency under the startup visa program. And if you search for startup visa, you will know our channel has always given the truth based on actual cases that IRCC is processing, not theoretical stuff. Okay. And if you think that this is too much to handle, well, you can always watch one of our more calm and relaxed videos that we always post on our social media. So thanks, folks, for tuning in. We're going to be back next week, Thursday, 11 a.m. Eastern Time. And next week, I think we're talking about Dubai Golden Visa. Should you invest or no? And of course, we've got Malta, we've got Panama, which in 90 days, you can get your permanent residency. And then remember, out of all the Caribbean islands where you can buy a passport, Grenada is the only one that is not on the U.S. State Department's watch list to be banned. Okay. And of course, we've got 20 other programs around the world, whether it's Portugal or Spain or Greece or Cyprus or Bulgaria or even Hungary. No matter what nationality you are, no matter where you're from, if you've got the financial resources, the intent, the motivation, the timeline to apply for a residency, citizenship, or investment, we're here to help you. Tabish Faruqi. Fan number 2. You're a top fan. Nice, nice, nice. Is SUV paused as of now? Tabish, great question. I call that the $1 million question for SUV Canada. It's not paused because still it's accepting applications. But for the last 6 to 7 months, IRCC has not processed any PR cases for the startup visa. And I'll tell you why. Okay. What's happening is this. This is theoretical. This is not fact. This is from what we understand. Startup visa and the IRCC immigration department, obviously, they cut the quotas of all immigration programs end of last year and even this year. Okay. What happened is that every program quota got cut. So from 6,000 startup visa applicants that were processed 5,000 and some change last year with a quota of 5,000 to 6,000, it was cut to 2,000. So this year they had a quota of 2,000. By the end of last year, they already had all these cases ready for decisions. So I'm talking about October to November, folks, December. What would have happened? And so these applications for startup visa would have issued a PR decision between January to March this year. Those would have filled 2,000 of the quota this year. What do you think the officer is thinking? If I make a decision now, I have nothing to do for 9 to 10 months for the rest of the year. How can I justify my salary that I'm working? So what's the best thing to do, right? The best thing to do is to clean up all the files, organize, do some structural changes, hold these 2,000 cases that you were about to issue a decision in January, February, March, and do it between September to December 2025. So you actually, look like you're doing something, took a year, and you met the quota, right? Imagine you're working at a McDonald's. You have a quota of making 20 hamburgers an hour. Well, it's probably about 50, I would say. Okay? And you could technically do all 50 in 10 minutes. Do you want to stand idling around for 50 minutes after you've done the 50 burgers? So your boss or manager is like, why is he not doing anything? What's going to happen? A, you may be fired. 2, demoted. 3, they'll give you 150 or 200 burgers to do in 1 hour, or maybe 500. Do you want that? No. Same mentality goes for the IRCC officers. They thought they had to process 5 to 6,000. Government cut the quotas, not just for startup, every single program out there in Canada. I don't care if it's PMP, skilled immigration, express entry, family sponsorships, asylum, you name it, they cut it. Now they only had 2,000. They already processed all these cases end of last year that were ready for decision Q1 2025. Now they got hit with a 2,000 quota. So what do? You just delay it and prolong it. So they had time to organize, look through the backlog, get everything ready, and also start a new strategy of how they will process these cases. So these new changes that are coming up in the second half of this year that will be announced by the IRCC most likely will be basically the fruits of the last 6 months of them internally reviewing and organizing. But you will have PR decisions, okay, up to maybe 2,500, 3,000 decisions coming your way second half of this year. So if you were waiting for a decision and you were at the 3-4 year mark with a non-priority in the last 12 months, you're going to get a decision. Okay, so it's not paused officially, but unofficially, Tabish, yes, unofficially, but they were still taking intakes. But the processing is starting. Folks, thanks for joining in. I talk too much, but I guess that's why we have this YouTube channel. Giving you the truth, giving you what's really happening out there. And by the way, more than 50% of the letters of support have already been spent, right? So actually more than 75, 80% of the active designated organizations have already met their so need to know what to look for. Do not apply for non-priority. If you're stuck on a 5-year trip, sorry if I had to burst your bubble, but then we'll be back next week. Every couple of weeks, we talk about startup visa, and in between, we talk about residencies and citizenship programs that are faster and maybe easier than Canada startup visa. We are a global mobility, residency, investment, and citizenship firm. We're fully licensed and insured. Our team speaks 10 languages. Worked with 20 different programs in countries around the world. I've personally in more than 5-6 different jurisdictions and lived in over 7-8 cities around the world. So I speak from experience, and I would never recommend a program that I would not personally invest in or recommend for my own immediate family. That is our promise to you. Okay? Take care. See you next week. Subscribe to our YouTube channel. Why? Well, it's free. And you can subscribe without having to call a 1-800 number and begging. Take care. Bye-bye. See you later.